Discuss the process of enacting laws. A bill is signed by its authors and filed with the Secretary of the House. It may originate from either the lower or upper house, except appropriation, revenue or tariff bills, bills authorizing increase of public debt, bills of local application, and private bills, which shall originate exclusively from the House of Representatives. 1. First reading. Reading of the number and title of the bill, which is then referred to the appropriate committee for study and recommendation, which may include the conduct of public hearings. The committee will submit its report and recommendation for calendar for second reading. 2. Second reading. Reading of the bill in full with the amendments proposed by the committee, if any, unless copies thereof are distributed and such reading is dispensed with. The bill will be subject to debate, pertinent motions, and amendments. After the amendments shall have been acted upon, the bill will be voted on, second reading. 3. Third reading. Submission of the bill as approved on second reading for a final vote by yeas and nays. 4. Conference committee reports. Transmittal of the bill approved on third reading by one house to the other house for concurrence. The other house shall follow the same procedure. If the other house approves the bill without amendments, the bill is passed by Congress, and the same will be transmitted to the President. If the other house introduces amendments, and with which the originating house does not agree, the differences will be settled. The conference committees of both houses. The conference committee's report will have to be approved by both houses in order that it will be considered passed by Congress and thereafter sent to the President. 5th, authentication of bills. Signing by the Speaker and the Senate President of the printed copy of the approved bill, followed by the certification by the respective secretaries of the both houses before it is sent to the President. 6. President's approval or veto. Transmittal of the authenticated bill to the President. If he approves the same, he shall sign it, otherwise he shall veto it and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof. Otherwise, it shall become a law as if he had signed it. 7. Reversal of veto. If after such reconsideration 2/3 of all the members of such House shall agree to pass the bill, it shall be sent together with the objections to the other House by which it shall likewise be reconsidered. And if approved by 2/3 of all the members of that House, it shall become a law. Q. Is the no amendment on the third reading clause applicable to the bicameral conference committee? No. The no amendment rule refers only to the procedure to be followed by each House of Congress with regard to bills initiated in each of said respective houses, before said bill is transmitted to the other House for its concurrence or amendment. Verily, to construe said provision in a way as to prescribe any further changes to all the bill after one House has voted on it would lead to absurdity, as this would mean that the other House of Congress would be deprived of its constitutional power to amend or introduce changes to said bill. Thus, Article 6, Section 26, Number 2 of the Constitution cannot be taken to mean that the introduction by the Bicameral Conference Committee of amendments and modifications to disagreeing provisions in bills that have been acted upon by both houses of Congress is prohibited. Abacadaguro Party List versus Armida. Q. Are the requirements of 3 readings on separate days and distribution of printed copies may be dispensed with? Yes. Both the requirements of 3 readings on separate days and distribution of printed copies thereof 3 days before its passage may be dispensed with upon the certification by the President of the necessity of the bill's immediate enactment to meet a public calamity or emergency. Q. What is the extent of the power of a conference committee? It is within the power of the Bicameral Conference Committee to include in its report an entirely new provision that is not found either in the House bill or in the Senate bill. And if the committee can propose an amendment consisting of one or two provisions, there is no reason why it cannot propose several provisions, collectively considered as an amendment in the nature of a substitute, so long as the amendment is germane to the subject of the bills before the committee. Tolentino versus Secretary of Finance. Quorum and voting majorities. Q. What is the quorum prescribed for the House of Congress? A majority of all the members of each House shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may compel attendance of absent members in such manner and under such penalties as such House may determine. Note: the existence of a quorum is based on the proportion between those physically present and the total membership of the body. Q. What is the difference between majority of all the members of the House and majority of the House? There is a difference between a majority of all the members of the House and a majority of the House, the latter requiring less number than the first. Therefore, an absolute majority, 12, of all the members of the Senate less 1, 23, constitute constitutional majority of the Senate for the purpose of a quorum. Cuenca versus Avellino, or Avellino versus Cuenca. Q. What is the basis in determining the existence of a quorum in the Senate? The basis in determining the existence of a quorum in the Senate shall be the total number of incumbent senators who are in the country and within the coercive jurisdiction of the state. Thus, a senator who is abroad, for whatever reason, is always discounted, while a senator who is in the country may still be counted even if comatose or detained, because they remain within the coercive jurisdiction of the state. Note: the same principle may be applied for the determination of quorum in the House of Representatives. Q. How many votes constitute a majority of all members? This refers to an absolute majority, which requires the majority of all electors regardless of the number of members present or absent during the time a question is put to a vote, provided a quorum exists. For example, even if only 23 senators are present at the vote, an absolute majority would require the concurrence of at least 13 senators, or 24 divided by 2 plus 1. For the House of Representatives, the number would be 126, which is 250 divided by 2 plus 1. Q. How many votes constitute a majority of the House? This refers to a type of simple majority which requires the concurrence of more than half the electors that are within the coercive jurisdiction of the House, provided there is a quorum. For example, suppose 3 senators are abroad, then a simple majority is at least 11, which is more than half the senators who are within the coercive jurisdiction of the Senate. Q. What is the nature of voting as regards the Congress' power to appoint officers? Example: majority and minority leaders in each House. The power to determine the manner of selecting such other officers is derivative of the exercise of the prerogative conferred by the Constitution that each House shall choose such other officers as it may deem necessary. While the Constitution is explicit on the manner of electing a Speaker of the House of Representatives, it is, however, silent on the manner of selecting other officers, thus leaving the same to the exclusive prerogative of each House. Hence, a candidate who garnered the second highest number of votes for speakership cannot automatically become the minority leader based on long-standing tradition, when such tradition was clearly overturned by the House of Representatives. Baguillet Jr. versus Alvarez. Q. What is the power of appropriation? The power of appropriation, called the power of the purse, belongs to Congress, subject only to the veto power of the President. It carries with it the power to specify the project or activity to be funded under the appropriation law. Q. What is an appropriation law? A statute the primary and specific purpose of which is to authorize the release of public funds from the Treasury. Q. Give the two classifications of appropriation laws. The following are the two classifications of appropriation laws. General appropriation law, passed annually, intended for the financial operations of the entire government during one fiscal period, and 2. Special appropriation law, designed for a specific purpose. Q. What are the limitations on the power to appropriate? The Constitution, under Articles 6, Section 24, 25, and 29, and Article 7, Section 22, provide explicit limitations on the power to appropriate. 1. All appropriation, revenue, or tariff bills, bills authorizing increase of the public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. 2. The Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. 3. No provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. Any such provision or enactment shall be limited in its operation to the appropriation to which it relates. 4. The procedure in approving appropriations for Congress shall strictly follow the procedures for approving appropriations for other departments and agencies. 5. A special appropriations bill shall specify the purpose for which it is intended and shall be supported by funds actually available as certified by the National Treasurer, or to be raised by a corresponding revenue proposed therein. 6. No law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of Constitutional Commission may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriations. 7. Discretionary funds appropriated for particular officials shall be dispersed only for public purposes, to be supported by appropriate vouchers, and subject to such guidelines as may be prescribed by law. 8. If by the end of any fiscal year the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by Congress. 9. Prohibition on the expenditure of public money or property for religious purposes. 10. The General Appropriation Law must be based on the budget prepared by the President. Q. What are the implied limitations on the power of the Congress to appropriate public funds? The following are the implied limitations on the said power. 1. The appropriation must be devoted to a public purpose, and 2. The sum authorized to be released must be determinate or at least determinable. Pascual versus Secretary of Public Works and Communications. Q. What are the requisites of a valid transfer of appropriations? The following requisites must concur. 1. There must be a law authorizing the President, the Senate President, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of Constitutional Commission to augment any item in the General Appropriations Law for their respective offices. And 2. The funds to be transferred are taken from savings in other items of the respective appropriations. Note, the list of those who may be authorized to transfer funds under the above provision is exclusive. Berna's Commentary on 1987 Philippine Constitution. Hence, neither the Chief of Staff of the Armed Forces nor individual members of the Congress may not be given such authority. What is a pork barrel? Pork barrel is an appropriation of government spending meant for localized projects and secured solely or primarily to bring money to a representative's district. Arroyo versus Aquino III. Q. What is a pork barrel system? The court defines the pork barrel system as the collective body of rules and practices that govern the manner by which lump sum discretionary funds, primarily intended for local projects, are utilized through the respective participation of legislative and executive branches of government, including its members. Belgica versus Ochoa. Q. Under the pork barrel system, what are the two kinds of lump sum discretionary funds? The pork barrel system involves two kinds of lump sum discretionary funds. First, there is the congressional pork barrel, which is herein defined as a kind of lump sum discretionary fund wherein legislatures, either individually or collectively organized into committees, are able to effectively control certain aspects of the fund's utilization through various post-enactment measures and/or practices. And two, there is a presidential pork barrel, which is herein defined as a kind of lump sum discretionary fund which allows the president to determine the manner of its utilization. Belgica versus Ochoa. Legislative increase and oversight functions. Q. What are legislative or formal inquiries? Legislative inquiries may refer to the implementation or re-examination of any law or appropriation, or in connection with any proposed legislation, or for the formulation of, or in connection with future legislation, or will aid in the review or formulation of a new legislative policy or enactment. They may also extend to any and all matters vested by the Constitution in Congress and/or in the Senate alone. Rules of Procedure Governing Inquiries in Aid of Legislation, Section 1. Legislative inquiry is inherent in Congress. The inquiry to be within the jurisdiction of the legislative body to make must be material or necessary to the exercise of a power in it vested by the Constitution, such as to legislate or to expel a member. Arnold versus Nazareno. Q. What is the scope of the power of legislative investigation by the Congress? The power of legislative investigation by the Congress involves the following. 1. Power to conduct inquiry in aid of legislation in accordance with its duly published rules of procedure. 2. Power to issue summons and notices in connection with matters subject to its investigation or inquiry. 3. Power to punish or declare a person in contempt during or in the course of legislative investigation. And 4. The power to determine the rules of its proceedings. Arnold versus Nazareno. Q. What are the limitations on the power of legislative investigation of the Congress? The following are the limitations of said power. 1. It must be in aid of legislation. 2. In accordance with duly published rules of procedures. And 3. The rights of persons appearing in or affected by such inquiry shall be respected. Q. How often should the rules of procedure and the conduct of legislative inquiry be published? The phrase duly published rules of procedure requires the Senate of every Congress to publish its rules of procedure governing inquiries in aid of legislation, because every Senate is distinct from the one before it or after it. Since senatorial elections are held every 3 years for 1/2 of the Senate's membership, the composition of the Senate also changes by the end of each term. Each Senate may thus enact a different set of rules as it may deem fit. The requisite of publication of the rules is intended to satisfy the basic requirements of due process. Garciliano versus House of Representatives. Section 21, Article 6 of the 1987 Constitution explicitly provides that the Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. Q. Discuss the oversight functions of the Congress. The heads of departments may, upon their own initiative, with the consent of the President or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their departments. Written questions shall be submitted to the President of the Senate or the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpellations shall not be limited to the written questions, but may cover matters related thereto. When the security of the Senate or the public interest so requires, the appearance shall be conducted in executive session. Q. Discuss the question hour vis-a-vis the oversight functions of the Congress. The Supreme Court referred to the oversight function of the Congress under Section 22, Article 6 as question hour. It was ruled that Section 21 and 22, therefore, while closely related and complementary to each other, should not be considered as pertaining to the same power of Congress. One specifically relates to the power to conduct inquiries in aid of legislation, the aim of which is to elicit information that may be used for legislation, while the other pertains to the power to conduct a question hour, the objective of which is to obtain information in pursuit of Congress oversight function. Senate versus Ermita. Q. Discuss the differences between the right of the Congress to conduct inquiry in aid of legislation, Section 21, and its oversight function, Section 22. The following are the differences between the two powers of the Congress. Section 21, right to conduct inquiry in aid of legislation. Section 22, oversight function of Congress. As to who may appear, Section 21, any person. Section 22, only an executive department head. As to who conducts the investigation, Section 21, committees. Section 22, entire body. As to the subject matter, Section 21, any matter for the purpose of legislation. Section 22, matters related to the department only. As to purpose, Section 21, Congress has the power to conduct inquiries in aid of legislation, the aim of which is to elicit information that may be used for legislation. Section 22, Congress has the power to question executive department heads, the objective of which is to obtain information in pursuit of Congress oversight function. As to attendance, Section 21, attendance is compulsory. Section 22, attendance is discretionary, hence it is valid for the President to require that consent be obtained first before subordinates appear in Congress during the question hour. Congress cannot request the appearance of executive officials if the required consent of the President is not obtained first, or if no such consent is given, while for Section 21, Congress can compel the attendance of executive officials subject to the per application of executive privilege. Q. Discuss the power of impeachment of the Congress. The House of Representatives shall have the exclusive power to initiate all cases of impeachment. The Senate shall have the sole power to try and decide all cases of impeachment. The President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution, treason, bribery, graft and corruption, and other high crimes, or betrayal of public trust. Note: no impeachment proceeding shall be initiated against the same official more than once within a period of 1 year. Initiation takes place by the act of filing and referral or endorsement of the impeachment complaint to the House Committee on Justice. Francisca versus House of Representatives. Q. What is the procedure of impeachment? The simplified procedure of impeachment is as follows. 1. Filing of a complaint. This starts the proceedings for impeachment. A. The complaint is filed either by a member of the House of Representatives or by any citizen upon resolution of endorsement by any member thereof. 2. Complaint is referred to the proper committee. A. The committee conducts deliberation of the complaint that was filed. Thereafter, the committee should decide whether the complaint is sufficient in form and in substance. B. The committee, after hearing and by a majority vote of all its members, shall submit its report to the House within 60 session days from the referral of the complaint together with the corresponding resolution. C. The resolution shall be calendared for consideration by the House within 10 session days from receipt thereof. D. A vote of at least two-thirds of the members of the House shall be necessary either to affirm a favorable resolution with the articles of impeachment of the committee or override its contrary resolution. The vote of each member shall be recorded. 3. Complaint is sent to the Senate, which will try and decide cases of impeachment. A. If filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment. 4. Trial and conviction. The Senate tries the impeachment and convicts by a vote of two-thirds of all the members of the Senate. Suarez, Political Law, 2018. Q. What is the composition of the electoral tribunals? Each electoral tribunal shall be composed of 9 members, 3 of whom shall be justices of the Supreme Court, to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate or the House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from the political parties and the parties or organizations registered under the party list system represented therein. The senior justice in the electoral tribunal shall be its chairman. Q. When must the electoral tribunals be constituted? The electoral tribunal shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized, with the election of the President and the Speaker. Q. Discuss the independence of the respective electoral tribunals of the House of Congress. The Electoral Tribunal is independent of the Houses of Congress, Angara v. Electoral Commission, and its decisions may only be reviewed by the Supreme Court upon showing of grave abuse of discretion in a special civil action for certiorari filed under Rule 65 of the 1997 Rules of Civil Procedure, Peña v. House of Representatives. Q. What is the function of electoral tribunals? The electoral tribunals act as the sole judge of all contests relating to the election, returns, and qualifications of the respective members of each House. Q. When does the House of Representatives Electoral Tribunal acquire jurisdiction over election cases? Once a winning candidate has been duly proclaimed, taken his oath, and assumed office as a member of the House of Representatives, the Comelic's jurisdiction over election contests relating to the candidate's election, returns, and qualifications ends, and the House of Representatives Electoral Tribunal's own jurisdiction begins. Lim Kai-chung versus Comelic. Note, the taking of oath or affirmation of members of the House of Representatives, either collectively or individually, shall be before the Speaker in open session. Section 6, Rule 2, Membership of the Rules of the House of Representatives, Reyes versus Commission on Election. Q. Can a membership in the HRET be terminated because of party disloyalty? Membership in the House Electoral Tribunal may not be terminated except for a just cause, such as the expiration of the member's congressional term of office, his death, permanent disability, resignation from the political party he represents in the tribunal, formal affiliation with another political party, or removal for other valid cause. A member may not be expelled by the House of Representatives for party disloyalty, short of proof that he has formally affiliated with another political group. Bondoc versus Pineda. Q. What is the composition of the Commission on Appointments? CA. There shall be a Commission on Appointment consisting of the President of the Senate as ex officio chairman, 12 senators, and 12 members of the House of Representatives, elected by each House on the basis of proportional representation from the political parties and parties or organizations registered under the party list system represented therein. Number of senators or representatives of a political party, total number of senators or representative times 12. Note, for the Senate, a political party must have at least 2 members to be identified to 1 seat in Commission on Appointments. Rounding off is not allowed. Gingona versus Gonzalez. Q. When must the CA be constituted? The CA shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and the Speaker. Q. Discuss the independence of the CA. The Commission is independent of the 2 houses. Its employees are not technically employees of Congress. It has the power to promulgate its own rules of proceedings. Pimentel Jr. versus Ermita. Q. What is the function of the CA? The CA acts as a legislative check on the appointing authority of the President. It shall act on all appointments submitted to it within 30 session days of the Congress from their submission. Q. Under the Constitution, which appointments need the concurrence of the CA? The President shall nominate and, with the consent of the Commission on Appointments, appoint 1. Heads of executive departments. 2. Ambassadors and other public ministers and consuls. 3. Officers of the EFP from the rank of colonel to naval captain. 4. Officers whose appointments are vested in him by the Constitution. A. Regular members of the Judicial and Bar Council. B. Chairmen and members of the Constitutional Commission. C. Sectoral representatives during the 3 consecutive terms after the ratification of the Constitution. Q. What are the appointments that do not need confirmation from the Commission on Appointments? The following are the appointments that do not need confirmation from the Commission. 1. Appointment of the Vice President to a cabinet position. 2. Members of the Supreme Court and judges of lower courts. 3. The Ombudsman and his deputies. 4. All other officers of the government whose appointments are not otherwise provided by law, and those whom he may be authorized by law to appoint. Example A. Commissioner of Customs. B. Chairman of the Commission on Human Rights. C. Appointments and promotions in the Philippine Coast Guard. Soriano versus Lista. Q. What is the procedure for appointment that need the confirmation of the CA? The procedure is as follows. 1. Nomination by the President. 2. Confirmation by the Commissions on Appointments. 3. Issuance of commission. And 4. Acceptance by the appointee. Lacson versus Romero. Q. Discuss the voting rules of the Commission. The Commission shall rule on all nominations or appointments brought before it by a majority vote of all its members. Only members present shall be entitled to vote. The ex officio chairman shall not vote, except to break a tie. All other matters shall be decided by a majority vote of the members present, constituting a quorum. Rules of Commission on Appointments. Voting by the Commission on any nomination or appointment submitted for confirmation shall be by viva voce, except upon request of any members. The voting shall be nominal. Rules of the Commission on Appointments. Q. Discuss the rules on unacted nominations or appointments returned to the President. Nominations or appointments submitted by the President of the Philippines which are not finally acted upon at the close of the session of Congress shall be returned to the President, and unless new nominations or appointments are made, shall not again be considered by the Commission. Q. Discuss the rules on reconsideration of resolution of the Commission. Resolution of the Commission on any nomination or appointment may be reconsidered on written motion by any member who voted with the majority or the prevailing side presented to the chairman not later than 1 day after the approval of the resolution, provided that said motion for reconsideration be taken up on the next plenary session of the Commission. If the majority of the members present approves such motion for reconsideration, the nomination or appointment shall be reopened and submitted anew to the Commission. A motion to reconsider the vote on any nomination or appointment may, however, be laid on the table, and which decision shall be considered as a final disposition of such a motion for reconsideration. A motion to reconsider, however, is not in order if filed during the last plenary session of the Commission prior to adjournment of Congress. Rules of the Commission and appointments. Q. What are the rules and meeting of the Commission? The Commission shall meet only while Congress is in session, at the call of its chairman or a majority of all its members. Q. What is the vote power of the member of the Commission? Any member may move for the suspension of action by the Commission on any nomination or appointment favorably recommended by a standing committee, and the chairman shall suspend the consideration of said nomination or appointment, provided that such suspension may be taken up on the next succeeding session of the Commission, provided further that this section shall not to apply to nominations or appointments taken up by the Commission during the last session prior to a sine die adjournment of Congress. Rules of the Commission on Appointments, Chapter 4, Section 20. Q. What is a people's initiative? People's initiative is the power of the people to propose amendments to the Constitution or to propose or enact legislation through an election called for the purpose. Q. Is RA 6735 sufficient and adequate to amend the Constitution through a people's initiative? RA 6735, also known as the People's Initiative and Referendum Act, is incomplete, inadequate, or wanting in essential terms and conditions insofar as initiative or amendment to the Constitution is concerned. Santiago v. Comelec. However, in the Supreme Court's minute resolution denying the motions to reconsider the dismissal of the petition for people's initiative, 10 members of the court reiterated their position that RA 6735 is sufficient and adequate to amend the Constitution through a people's initiative. Minute resolution Lambina v. Comelec. Subsequently promulgated on January 2, 2007, setting forth the rules and regulations to govern the conduct of initiative on the Constitution. The Comelec. Q. What are the classes of people's initiative? There are 3 classes of people's initiative to it. 1. Initiative on the Constitution, petition proposing amendments to the Constitution. Number 2. Initiative on statutes, petition proposing to enact a national legislation. And 3. Initiative on local legislation, petition proposing to enact a regional, provincial, city, municipal, or barangay law, resolution, or ordinance. RA 6735. Q. What is referendum? Referendum is the power of the electorate to approve or reject legislation through an election called for that purpose. Q. What are the classes of referendum? There are 2 classes of referendum to it. 1. Referendum on statutes, petition to approve or reject an act or law or part thereof passed by Congress. And 2. Referendum on local laws, legal process whereby the registered voters of the local government units may approve, amend, or reject any ordinance enacted by the Sanggunian. Q. What are the qualifications required of the President and Vice President? A person must meet the following qualifications to be elected President or Vice President. 1. Natural-born citizen of the Philippines. 2. At least 40 years of age on the day of the election. 3. Able to read and write. 4. A resident of the Philippines for a period of at least 10 years, immediately preceding the day of the election. Q. How long is the term of the office of the President and Vice President? The President and the Vice President shall be elected by direct vote of the people for a term of 6 years, which shall begin at noon on the 30th day of June next following the day of the election, and shall end at noon on the same date 6 years thereafter. Note: the person having the highest number of votes shall be proclaimed elected. but in case two or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of the Congress, voting separately. Q. Discuss the rules on the President's and Vice President's election and eligibility for re-election. The President and the Vice President shall be elected by direct votes of the people for a term of 6 years, which shall begin at noon on the 30th day of June next following the day of the election, and shall end at noon on the same day 6 years thereafter, unless otherwise provided by law. The regular election for President and Vice President shall be held on the second Monday of May. The President shall not be eligible for any re-election. No person who has succeeded as President and has served as such for more than 4 years shall be qualified for election to the same office at any time. No Vice President shall serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. Q. What are the privileges afforded to the President and Vice President? The following are their privileges. 1. Official residence for the President, and 2. Salaries of the President and Vice President are determined by law and not to be decreased during his tenure. 3. Presidential immunity from suit during his tenure. 4. Executive privilege, presidential communications privilege, has been defined as the right of the President and high-level executive branch officials to withhold information from Congress, the courts, and ultimately the public. Senate versus Ermita. Q. What is the extent of President's immunity from suit? The President, like the judges of the courts and the members of the legislature, may not be personally mulcted in civil damages for the consequences of an act executed in the performance of his official duties. This principle of non-liability does not mean that the chief executive may not be personally sued at all in relation to acts which he claims to perform as such official. The President is liable when he acts in a case so plainly outside of his power and authority that he cannot be said to have exercised discretion in determining whether or not he had the right to act. Also, when the cases filed against the President are criminal in character, it will be anomalous to hold that immunity is an inoculation from liability for unlawful acts and omissions. The rule is that unlawful acts of public officials are not acts of the state, and the officer who acts illegally is not acting as such but stands in the same footing as any other trespassers. Estrada versus Desierto. Q. What are the inhibitions and disqualifications imposed upon them? The following are the inhibitions and disqualifications under the law. 1. Shall have no increase in salaries during their tenure. 2. Shall not receive any other emoluments from the government or any other source. 3. Shall not hold any other office or employment unless otherwise provided in the Constitution. 4. Shall not directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with, or in any franchise or special privilege granted by the government, or any subdivision, agency, or instrumentality thereon, including GOCCs or their subsidiaries. 5. Strictly avoid conflict of interest in the conduct of their office. 6. May not appoint spouse or relatives by consanguinity or affinity within the 4th civil degree as members of Constitutional Commission or the office of the Ombudsman, or as secretaries, undersecretaries, chairmen, or heads of bureau or office, including GOCCs and their subsidiaries. Powers of the President, executive and administrative powers in general. Q. Distinguish executive power from an administrative power. Executive power pertains to the power to enforce and administer the laws. It shall be vested in the President of the Philippines and exercised through the manifold offices of the executive department. On the other hand, administrative power refers to the President's control over all such executive departments, bureaus, and offices. He shall ensure that laws are faithfully executed. Q. What is the power of administrative reorganization? It is the President's continuing authority to reorganize the executive branch, which includes the power to group or consolidate bureaus and agencies, to create and abolish offices, to transfer functions, to create and classify functions, services and activities, and to standardize salaries and materials. It is effected in good faith if it is for the purpose of economy or to make bureaucracy more efficient. MEWAP versus Executive Secretary. Q. Discuss the faithful execution clause. The second sentence of Section 17, Article 7 is referred to as the take care power of the President and also sometimes called the faithful execution clause. Under this provision, the President is bound to ensure the faithful execution of laws, regardless of his belief in the legality of said laws. Until and unless a law is declared unconstitutional, the President has a duty to execute it regardless of his doubts as to its validity. Power of appointment. Define appointment. An appointment is the selection by the authority vested with the power to do so of an individual who will be tasked to exercise the functions of a given office. It differs from a designation in that the latter simply means the imposition of additional duties, usually by law, on a person already in the public office. It is also different from a commission, which refers to the written evidence of the appointment. What is the nature of the power to appoint? The power to appoint is essentially executive in nature, and the legislature may not interfere with the exercise of this executive power except in those instances when the Constitution expressly allows it to interfere. Pimentel versus Ermita. What are the limitations in the President's appointing power? The following are the limitations in the President's power. 1. Limitations on the executive power to appoint or construe strictly against the legislature. The scope of the legislature's interference in the President's power to appoint is limited to the power to prescribe the qualifications to an appointive office. Congress cannot appoint a person to an office in the guise of prescribing qualifications to that office. Neither may Congress impose on the President the duty to appoint any particular person to an office. 2. The CA is independent from Congress and does not legislate when it confirms or refuses a presidential appointment. 3. The President has no constitutional or legal obligation to only make permanent appointments when Congress in session. 4. The President can also make temporary appointments even when the commission and appointment is in session. Pimentel versus Ermita. 5. The President is constitutionally prohibited from making midnight appointments except under certain conditions. What are the kinds of presidential appointments? The following are the kinds of presidential appointments. Regular presidential appointments with or without confirmation by the Commission on Appointments, including recess or ad interim appointments. 2. Appointments made by an acting president. Number 3. Midnight appointments. Appointment made by a president within 2 months before the next presidential elections and up to the end of his term. What are the appointments that can be made solely by the President? The following are such appointments. 1. Those vested by the Constitution and the President alone. 2. Those whose appointments are not otherwise provided by law. 3. Those whom he may be authorized by law to appoint. And 4. Those other officers lower in rank whose appointment is vested by law in the President alone. Can the President legally appoint officers in charge in arm? Yes, the President shall appoint all other officers of the government whom the President may be authorized by law to appoint. Constitution, Article 7, Section 16. Since the President's authority to appoint OICs emanates from RA number 10153, it falls under this group of officials that the President can appoint. Thus, the assailed law rests on clear constitutional basis. Datu Michael Abbas Kida versus Senate of the Philippines. Which presidential appointments require confirmation by the Commission on Appointments under the Constitution? The President shall nominate and, with the consent of the Commission on Appointments, appoint 1. Heads of Executive Department, 2. Ambassadors and other public ministers and consuls, 3. Officers of the AFP from the rank to colonel or naval captain, 4. Officers whose appointments are vested in him by the Constitution, like regular members of the Judicial and Bar Council, b. Chairmen and members of the Constitutional Commission, c. Sectoral representatives during the 3 consecutive terms after the ratification of the Constitution. What is a bypassed appointment? A bypassed appointment is one that has not been finally acted upon on the merits by the Commission on Appointments at the close of the session of Congress. There is no final decision by the Commission on Appointments to give or withhold its consent to the appointment as required by the Constitution. Matibag versus Benipayo. What is the primary effect of a bypassed appointment? Nominations or appointments submitted by the President of the Philippines which are not finally acted upon on the close of the session of Congress shall be returned to the President, and unless new nominations or appointments are made, shall not again be considered by the Commission on Appointments. Is there a limit as to the number of times the CA can review the President's reappointment of a bypassed appointee? Yes. A nomination or appointment which has been bypassed 3 times shall be reported out by the Standing Committee concerned to the Commission for its appropriate action in the next plenary session, provided that no member shall be allowed to invoke the suspension of the consideration of the appointment. In this regard, the new rules of the Commission on Appointments, Section 25. What are midnight appointments? Midnight appointments are appointments made by the President within 2 months before the next presidential elections and up to the end of his term. Is the prohibition on midnight appointments absolute? No. The President or acting President may make temporary appointments to executive positions when continued vacancies therein will prejudice public service or endanger public safety. Does the prohibition apply to the appointments made by the President in the judiciary? No. The prohibition on midnight appointments does not apply to appointees to the judiciary. The fact that Section 14 and 16, Article 7 refer only to appointments within the executive department renders conclusive that Section 15 also applies only to the executive department. The framers did not need to extend the prohibition to appointments in the judiciary because their establishment of the JBC and their subjecting the nomination and screening of candidates for judicial position to the unhurried and deliberate prior process of the JBC ensured that there would no longer be midnight appointments to the judiciary. De Castro versus Judicial and Bar Council. What are the rules on the President's power of removal? The general rule is that from the express power of appointment, the President derives the implied power of removal. Exceptions to this rule are those appointed by him where the Constitution prescribes certain method for separation from public service, example, impeachment under Section 2, Article 11, 1987 Constitution. Note, in cases where the power of removal is lodged in the President, the same may be exercised only for causes as may be provided by law and in accordance with the prescribed administrative procedure. The President may directly discipline the members of the career service of the civil service who are appointed by him. Villaluz versus Saldivar. Can a law vest the President with disciplinary authority over a deputy ombudsman? No. To subject the deputy ombudsman to discipline and removal by the President, whose own alter egos and officials in the executive department are subject to the ombudsman disciplinary authority, cannot but seriously place at risk the independence of the office of the ombudsman itself. The office of the ombudsman, by express constitutional mandate, includes its key officials, all of them tasked to support the ombudsman in carrying out her mandate. Unfortunately, intrusion upon the constitutionally granted independence is what Section 8, Number 2 of RA 6770 exactly did. By so doing, the law directly collided not only with the independence that the Constitution guarantees to the office of the Ombudsman, but inevitably with the principle of checks and balances that the creation of an Ombudsman office seeks to revitalize. Gonzalez versus Office of the President. Power of control and suspension. Distinguish control from suspension. The power of control is the power of an officer to alter or modify or set aside what a subordinate officer had done in the performance of his duties, and to substitute the judgment of the former for the latter. The power of supervision is defined as the power of a superior officer to see to it that lower officers perform their functions in accordance with law. Joelbido Onon versus Fernandez. Discuss the doctrine of qualified political agency or the alter ego principle. All executives and administrative organizations are adjuncts of the executive department. The heads of the various executive and except in cases where the chief executive is required by the Constitution or law to act in person or the exigencies of the situation demanded that he acts personally. The multifarious executive and administrative function of the chief executive are performed by and through the executive departments, and the acts of the secretaries of executive departments, when performed and promulgated in the regular course of business, are, unless disapproved or reprobated by the chief executive, presumptively the acts of the chief executive. Carpio versus executive secretary. Note, thus, the executive secretary, when acting by authority of the president, may reverse the decision of another department secretary. Lacson Magallanes versus Pano. The decision of the cabinet secretary carries the presumptive approval of the president, and there is no need to appeal the decision to the president in order to complete exhaustion of administrative remedies. Kilusang Bayan versus Dominguez. Does the president exercise power of control over the executive departments and offices? Yes. The president shall have control of all executive departments, bureaus, and offices. This includes restructuring, configuring, and appointments of their respective officials. He shall ensure that the laws be faithfully executed. Discuss the power of the president to supervise local government units. The President of the Philippines shall exercise general supervision over local governments. Constitution, Article 10, Section 4. The President may only interfere in the affairs and activities of a local government unit if he or she finds that the latter had acted contrary to law. Any directive, therefore, by the President or any of his or her alter egos seeking to alter the wisdom of a law confirming judgment on local affairs of an LGU is a patent nullity because it violates the principle of local autonomy and separation of powers of the executive and legislative departments in governing municipal corporations. The Dole versus Commission on Audit. What are the military powers vested on the President? The President is the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out the armed forces to prevent or suppress lawless violence, invasion, or rebellion. In case of invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the writ of habeas corpus or place the Philippines or any part thereof under martial law. Discuss the calling out power of the President. The President, as Commander-in-Chief of all armed forces of the Philippines, may call out the armed forces to suppress lawless violence, invasion, or rebellion whenever it shall be necessary. It is the most benign of the military powers of the President and is merely incidental to his authority to determine the disposition of the armed forces and what degree of force a particular crisis demands. It is limited, however, to ordinary police action necessary to maintain public order. IBP versus Zamora. Does the Congress have the power to extend martial law? Yes, the Congress has the prerogative to extend the martial law and the suspension of the privilege of the writ of habeas corpus, as the Constitution does not limit the period for which it can extend the same. Lagman versus Medialdea.